So anytime, whenever you are using such digital platforms, digital apps, food delivery apps, anything in the digital age, you are leaving a traces of your personal data. There are many companies who are offering their services in India, but the companies are not Indian. It is not an Indian based company. So again, a lot of social media platforms you see these days, they're not Indian based companies. So whether if you're using such platforms, are your data protected? Many times you must have seen, whenever you download a particular piece of app, they ask you for permissions, that do you give permission to access your contacts, do you give permission to access your location, do you give permission to for any other thing as per the norm of that particular app. Then we have storage limitation. If you have given a data, the company has used that particular piece of data, so that data has to be deleted. Then we have a lot of policies, we have a lot of rules and regulations, but the compliance is very less. This is where the penalty is very high. Hello everyone. Recently, Ministry of Electronics and Information Technology has came up with Digital Personal Data Protection Rules 2025. In 2023, the Parliament enacted the Digital Personal Data Protection Act of 2023. So with these new rules coming up, that is going to fully operationalize the Digital Protection Data Act. That is talking about the whole idea of personal data protection in India. So we are going to discuss very thoroughly and understand it from UPSC examination perspective, that how important it is for us as far as this examination is concerned. So let's look at it. All of you, again, one question I would like to ask all of you must have used any of the apps, right? So again, in this whole digital age, we are using a lot of apps, we are using a lot of digital platforms. For example, we are ordering food online, we are using Aadhaar based services. So anytime, whenever you are using such digital platforms, digital apps, food delivery apps, anything in the digital age, you are leaving a traces of your personal data. So how exactly those data are being used? How are those companies using the data of the consumers who are providing it to them? Maybe you're logging into Netflix, you are logging into a YouTube channel, anything. This is where you're sharing or you're leaving back the traces of your personal data. And this is where we talk about in the new age of digital personal data protection, which is going to talk about the rights of the consumers or the users who are sharing their data in these platforms, and what kind of rights they have, and how are these companies going to be accountable with respect to the use of such data which users have provided to them. This is where, or again, UPI transaction, you talk about different kind of platforms which you are using, you are sharing your data. This is where this new rules is going to operationalize the Digital Personal Data Protection Act of 2023. Clear? So again, in this new era of digital age, what we are seeing, that again, how data has become the new gold, data has become the new oil. So this is the importance of data these days. And we are also seeing that how these data are misused sometimes. We see incidences of phishing attacks, we see fraud which has been conducted due to these data leakages. We talk about deep fakes, we talk about unauthorized profiling. So this is where there was no specific law which was protecting Indian users' personal digital data. So as far as Indian Constitution is concerned and Supreme Court judgments, in the famous Puttaswamy judgment of 2017, Supreme Court emphasized that right to privacy is a fundamental right under Article 21 of the Indian Constitution. And this is where the Supreme Court directed the government that again, this is in high time that you need to modernize, you need to make Northern Data Protection Act. This is where the origin and the genesis of this idea of data protection or digital data protection came into picture. So as users, we have fundamental right to privacy. So this is where the privacy also comes into picture with respect to the data what I am sharing in these digital platforms. This is all about this act. So this DPDP Act plus this rules is going to make sure that how checks and balances, how certain rights, how accountability is going to be maintained as far as the digital data protection in India is concerned. So let's look at that. This is where the act comes to picture. Again, let's conceptualize it with the examination perspective. All of you must have read the political functioning system of the country, I'm assuming. So you know the three organs of the government: executive, legislature, and the judiciary. And you know, of course, know about what are their functions. So legislature is the organ of the government who are making rules. So this is where the Parliament of India had made an act, that is Digital Personal Data Protection Act of 2023. So legislature did its function or its duty of making rules, right? And an act was being made that tells that digital personal data protection has to be done. It is mandatory. Now came the role of executive organ of the government. What is the task of executive? It does the task of implementation of those rules, implementation of the law. So this is where the Ministry of Electronics and Information Technology has came down with the digital personal data protection rules, which is going to make sure how exactly the act which was made by the Parliament is going to be implemented, and what are the ways how exactly we are going to make that implementation process. This is where the rules comes into picture. So this is where it talks about the ideas of citizen-centric privacy, respecting the idea of Puttaswamy judgment, that right to privacy is a fundamental right under Article 21. The ideas of digital governance, because the government has been promoting the idea of Digital India mission. We have talked about the importance of e-governance, right? This is where digital governance is also going to be coming into picture as far as this topic is concerned, and the use of data in a responsible manner. This is going to respect the privacy right, which is a fundamental right under Article 21 of the Indian Constitution. And it is again going to be aligning with the GDPR rules, principles. For example, the general data protection rules. So this basically rules is applicable to all of the European Union citizens. This is where it is a law which is protecting the data of all EU citizens. And on the same line, India has also come up with its own rule, own law, how the data of Indians is going to be protected. So let's discuss what exactly this act is and what this rule is all about. So what were the objectives of the act? Again, I am clearly putting forward that this is something talking about the digital personal data with legal clarity. Many times we understand we give permissions to the law, a lot of apps, we share our data, but we do not acknowledge the fact how are these data used. Many times you must have observed that again you are thinking, you're talking something, and some or the other way, whenever you open your browser, some of the ad or some of the advertisement related to that thing which you were talking about or you were discussing or you were browsing will pop up in your respective browsers. How it is happening? Again, the use of artificial intelligence, the use of data. So this is something which is not correct, that your data you are sharing, but it is something used in a manner which you have not given the consent. This is where this act talks about that we need to have a legal clarity with respect to how our data is going to be used. Then it is going to make sure that whatever data we are sharing with the platforms, they are going to be used in fair, lawful and transparent manner. Then it is going to make sure every individual is going to be empowered with simple and enforceable rights. People need to be aware that if I am sharing any data, if I am the source of that particular data, what kind of rights I hold with respect to how this data is being used. Then it is going to make organizations accountable, that again you are going to do audits, that how the data are used, what kind of usage of data is being used, right? Whether the consumers or the users are aware that how exactly their data are going to be used. All such things is going to be there. Any data leakage, any breach happening in the user data, that is all this Act and rules talk about, then we are going to build digital trust with an age of AI, with the age of cloud computing, with the age of digital public infrastructure. Many people are not trusting these platforms with respect to how these data are going to be misused or misused, because we have seen incidences of maybe fraud transactions, digital frauds, we have seen phishing attacks, we have seen maybe a lot of maybe data fraud issues, deep fakes. This is where people get or are not trusting with respect to how our digital data is going to be protected. So this is where uh, European Union has came up with the GDPR rules we have discussed. So again, India has also come up. These are the basic objectives of this particular framework. Then, what is the scope and where does this DPDP Act 2023 is going to be applicable to? Let's understand this key, where it will be applicable and where it not be applicable. So any digital personal data which is being collected by any of the user in India is going to be protected in this particular act. Number two, offline data. Let's say any company or any, let's say, platform is collecting any of your data in an offline manner and in a pen paper manner, and now they are converting that data into digital format, then also your data is going to be protected and you will going to get basic rights under this DPDP Act. Clear? Number three, that how data is going to be processed in India, that is going to be protected here, of course, here. Now, there was a lot of confusion that there are many companies who are offering their services in India, but the companies are not Indian. It is not an Indian-based company. So again, a lot of social media platforms you see these days, they're not Indian-based companies. So whether if you're using such platforms, are your data protected? This is something which was a major point of contention, and this act has made it clear that any company, irrespective of its origin, if it is providing services to Indian users, it is going to be coming under this particular act, right? So that is the scope of this act. Where and what exactly is not covered in this particular act? So any offline only, as I discussed, offline data, if it is converted into digital data, then only that will get a protection. But all offline data are not protected under this particular act. Very obvious, because they are not digital data. Then any household and personal use data. Let's say you are saving someone's number in your mobile phone. So those data are not protected under this particular act. And it is going to make sure that national security, law enforcement, government notified exemptions with safeguards are not protected under this particular act. So we got to know what is covered and what is not covered. Then whenever you're reading any piece of act, there are some key terms which we need to understand. This is where that comes into picture. Number one is data principal. So who is this data principal? The user who is providing his or her data to a platform is called as digital principal as per this particular act. If I am using any app, if I am giving any data to any of the company, any app, any website, then I, as per this act, become the data principal. The act also tells in case of children, because children are minors. So in case of children does not become a data principal. The guardian in that case is going to give consent to that particular platform. For example, let's say a 14-year child has downloaded a particular gaming app and he is giving some data, right? This is where the guardian becomes, in that case, the data principal. In case of persons with some disabilities who are not in a position to authorize the data which they are providing, again, the legal guardian becomes the data principal in that particular case. So technically, the basic understanding is the person who is sharing his or her data is called as data principal as per this particular act. Then there is a concept of data fiduciary. So any company which is collecting your data, that is called as data fiduciary as per this particular act. Let's say, so any company which is collecting your data, how they are going to use your data, what kind of data they are asking for. So that becomes the data fiduciary. So any company, for example, any social media platform, you're uploading your images, you're uploading your photos, how exactly those photos, your personal information, personal contact, how they are going to be used, that is something dependent on this data fiduciary. So they are called as data fiduciaries. Any company who is collecting your data, any app, any website, any company, so that is called as data fiduciary. Then is data processor. Many a times, the companies who are collecting your data are not directly processing your data. They are taking help of some third-party companies to process that data. For example, a bank has collected, a bank of course has all of your personal data. So now bank is not processing the data. It has maybe taken a help of a third party, that is a cloud storage, some of the company, who is the one who is processing your data. So that is called as data processor as per this particular act. So the data fiduciary who is appointing any third party to process that particular piece of data, that is called as data processor. Then there is consent manager. Many times you must have seen, whenever you download a particular piece of app, they ask you for permissions, that do you give permission to access your contacts, do you give permission to access your location, do you give permission to for any other thing as per the norm of that particular app. This is where every time you download an app, every app requires some specific segments they're asking for the approval. This is where we are going to come up with something called as consent manager. So there will be one app which is going to give authorization to all other apps with respect to the content which it wants to share. And this is going to make sure that again you have a clear visualization through that particular piece of app, in which app, in which website, in which area I have given my access of data, in which thing. And again, you can withdraw that consent, you can withdraw that data at any point of time using this particular app. Then again, of course, for this particular application, we have come up with digital protection board who is going to address and see all such implementation process, all issues, any complaints is going to be going over there. But after that also, if a user is not satisfied with the services which is going to be given by this digital protection board, then there is also a creation of a tribunal. So tribunals, of course, you know this. So tribunal in this case is the Telecom Dispute Settlement and Appellate Tribunal, which is the body which is going to hear appeals against the decision of this digital protection board. Clear on this? This is where the key definitions of the act come into picture. Then with respect to privacy principles, so the entire DPDP Act of 2023 is based on the 7 core privacy principles. What are those? Number 1, consent and transparency. So whenever a company is asking you any kind of data, any kind of permission, that has to be very much clear and explicit. Many times you see a lot of consent is being asked, such long paragraphs are there and you do not read it and you just click on the tick box and again you give the consent. This is where this app tells that whenever you are asking any piece of data, you need to very specifically ask what kind of consent are being given by putting up clear notices and in a very easily understandable knowledge, so that a consumer or a user who is providing his or her data has a knowledge what kind of data this company is asking for me. Clear on this? Number 2 is purpose limitation. What is the meaning of purpose limitation? If you have given authorization to a company to access your mobile number to send OTPs, so only for that purpose that mobile number is going to be used, not for sending you advertisements, not for sending any kind of information apart from giving that OTP. So the idea is, if you have given a data for a specific purpose, that data is only to be used for that particular purpose. Clear? Then we have data minimalization. So again, as discussed, only ask for essential piece of data what is required. For example, a food delivery app was only requiring basic information of your address. It does not require information about your background, about, let's say, your education information. So the idea, of course, here is ki only ask data what is required by that particular company to give you certain services. Then accuracy. Many times we see a lot of insurance apps, a lot of maybe medical apps, a lot of service-based apps, our data keeps on changing, right? So we have to make sure, the companies have to make sure that whatever data is being provided by the user has to be updated, and if it is not there, it is responsibility of the company to get that data updated. Clear? Then we have storage limitation. If you have given a data, the company has used that particular piece of data, so that data has to be deleted. Then the idea is the data should be there with the company till only that point of time. That is the company usage policy. If that data is processed, if that data what it was asked for is being used, then that data has to be deleted. There has to be no idea of keeping that piece of data in the entire time, right? So whenever the data is being used, you're going to delete that particular piece of data. Then security safeguards. All of the data which is being given by users to these platforms, that is data fiduciaries, they're going to make sure the data is kept in a secure, safe manner. Again, of course, there are different kind of mechanisms: encryption, audits, secure design, and data breach prevention has to be ensured. And lastly, this accountability. So all data fiduciaries should be held accountable for any kind of misuse of data which are being provided by these users, for compliance, for processors, and for user grievance redressal mechanisms. Then we have Data Protection Board. As I discussed, just only implementing the law, it requires a board or a body to be set up who is going to hear complaints or issues arising out of this particular piece of legislation. This is where we have come, this act has come up with Data Protection Board, which is a body, a complete online body who is going to make sure that it is going to regulate the data. And as far as hearing of issues, complaints are concerned, it is going to have a power of a civil court in case of awarding any piece of judgment. Then investigations are allowed. Any investigation of data breach, privacy violations, any complaints are going to be addressed by this particular board. Then it can summon documents, it can conduct hearings, it can go for audits for such companies where again there is a data breach which has happened. Then issues which are, or maybe any kind of guidelines which are provided, are binding, and this is going to be made sure by this Data Protection Board. It has a power to impose penalties. Again, I'll discuss what kind of penalties are there for what kind of breach of privileges. That is also going to be done by this board. And lastly, it is going to make sure that this entire act is implemented in a uniform manner across all sectors. This was a problem as of now. We did not had any kind of uniformity, but this act is going to make sure that this data protection or digital personal data protection is going to be uniform across all sectors, starting from tech, health, fintech, across government services as well. Then with respect to penalties, this is where very important, and if you look at the number and the amount of penalty, it is very high. Because what we have seen, we have a lot of policies, we have a lot of rules and regulations, but the compliance is very less. This is where the penalty is very high, so that the compliance becomes very much sure. And again, companies are very much going to be complying with the recent rules. Number one is, there is a penalty of 250 crores in any point of time that if there is a data breach or any reasonable security safeguards are being compromised by these big data companies who are called as what? Data fiduciaries, then there is going to be an imposition of 250 crore penalty. Then in case of non-notification, let's say, and it's very important, again, whenever there's a data breach, this board has to be informed. Right? If the company is not informing the board regarding the data breach, then there is a penalty of 200 crores. As I discussed, in case of children, the data is very sensitive. So if there is any kind of breach in the way the children data are being used, If it is being found, then there is again going to be a penalty of 200 crore rupees. And for again, we are going to discuss different kind of rules and regulations. Any kind of violation of rules which is given under here, if it is being found, then there is going to be a penalty of 50 crore rupees. The idea, of course, here is that we are going to create a mechanism which is very strong deterrent, so that compliance automatically comes from these companies. Clear? Then, with respect to the rules, so again, we discussed a lot about the act. Now, the DPDP rules, it is going to make sure that how exactly data is collected. All users should give their consent whenever the data is being asked. Then, any breach which is of data is being done in any company, that has to be reported. Users should know about the rights what they have with respect to the data what they have shared with these companies. Significant data fiduciary obligations. What are the obligations with respect to the companies who are collecting your data? The digital protection board is again going to function in a very digital manner, complete digital. And lastly, the compliance timeline. So this is something the rules talk about. Number one is the implementation process. Again, the rule has come up now. So again, we are going to give time, and the time which has been given to the companies is of 18 months. In the next 18 months, the companies are going to make sure that again we are going to comply with the new DPDP rules. For that, again, organizations have been given time to set up the, or maybe comply with all such things. They are going to do all basic requirements as for this particular act, and they are going to make sure that again there has to be a mandatory separate consent notice which has to be given to the users, right? And it has no link with something clubbing with the terms and conditions that was usually being done. So an explicit notice in a very simple language has to be given to all users with respect to the data asking process. Then they must explain that how data is going to be used, what kind of data they are going to be using, and again, how a user can withdraw the data what he or she has shared with the company. Then all consent managers, the one-stop app, which is going to talk about that how consent has to be given to different apps. This is going to be completely Indian company. So the jurisdiction and accountability of the consent managers lies with India only. Then it is of course going to make sure this timeline that again the DPDP rules are going to be implemented in a smooth manner. Again, a process of implementation of law, that again you cannot expect something that again something which is done today gets implemented the next day. You have to give time. This is something which this act has done. Then personal data breach protocol. Let's say a company who has collected your data and there is a data breach which has happened. So in that case, the rule says this is the process the company need to follow. That is the data fiduciary. So data fiduciary is going to immediately inform the user in case of data breach. Until now, it was not happening. So in case of any data breach, the user who has shared that data has to be informed that this data breach has happened with a clear message. Then in very plain language, it is going to get explanation. It is going to explain that why this data breach has happened. No technical terms, no jargons, in a very plain, simple language. Then it is going to include what all things, that what has happened, what data is exposed to the data breach, what are the possible harms. Let's say if you have shared any piece of data with the social media platform, then again, any case of identity theft, all such maybe expected outcomes of the data breach has to be explained to the user, and then what company is doing for that data breach scenario. This is something. And then any point of contact with respect to any issue, any concern of the user, a point of contact detail has to be shared, and the digital protection board has to be informed without any delay with respect to this. And again, we have seen if there is a delay, there is going to be a penalty of how much rupees? 200 crore rupees. This is where the process a company has to follow whenever there is going to be a data breach. Then we talk about transparency and accountability of this data fiduciary. Again, data fiduciary is what? Any company to whom you are sharing your data. Clear? So in terms of that, they are going to share the contact information of the data protection officer or the grievance officer. Let's say a X app or any app, let's say XYZ app, if it is collecting your data, should also give you a point of contact of grievance officer or a data protection officer whom you should contact in case of any grievance. Then all of the data records have to be very clearly maintained and documented. Then there are some big companies who has a very huge user base, so they have an added accountability. Of course, this is going to happen because much of data, a huge amount of data is there with them. So data protection impact assessment. You know about environmental protection impact assessment. This is where whenever any new kind of application of data is going to be done, for example, artificial intelligence, biometrics, high risk tech, this is where firstly we need to check that how impact or what kind of impact this new process is going to be bringing about. Number one. Number two, stricter monitoring for profiling and large scale data processing. Then follow government directions on, there are certain restrictions of course which government will have with respect to processing of certain kind of data, for example health data. And lastly, it may require local storage for sensitive categories of data, not in the companies but at a local level the data has to be stored. Then with respect to strengthening data principle, who are data principle? Again, the users who are going to give consent, whose data are going to be shared. So if I am a user, I am called as data principal. So for me, what kind of rights I do have? I have a full right to access any kind of stored data with any app, any website which I have shared with. Then any point of time I need to correct my data, I need to withdraw my data, that has to be done. Any updation has to be done. Erasing of data has to be there. So nominate representative. Again, in case of disability, in case of illness, I can nominate someone on my behalf to give the consent. And lastly, all requests of these nature, there's a timeline also. Because many times we mail, we don't get a reply. But here, the timeline is fixed. Within 90 days, you have to give all such piece of maybe services to the data principal. So these are the rights. Everyone should be aware because we all are in the digital platforms. We should be aware. So these are the rights which are being provided under the DPDP rules of 2025. Then Digital First Data Protection Board, as per the board which has been set up, which is going to overview the entire maybe implementation process of this DPDP rules. Number one, it is going to fully online, no office, completely online. Complaint filling portal is there, mobile application will be there, digital evidence submission has to be done, AI enabled case tracking, you can track where your case is, how much processing has to be done, where is your situation with respect to any complaint which you have made to this board, and standardized forms for user request. If I have maybe issue with respect to data breach, if I had issue with respect to data, let's say updation, so certain standard formats has to be maintained. So again, the benefits is, with this digital way of doing things, we are going to see faster resolution, we are going to see transparency and the reduced bureaucratic delays. Don't you think this is a solution for e-governance, the solution for digital governance? Again, a clear example. Then with respect to alignment with the RTI Act, very important. So this coming of DPDP rules has amended one section of the RTI Act. What is this Right to Information Act, which talks about the ideas of transparency in the governance process? What is this DPDP Act? It talks about privacy. Both are very important pillars of democracy. This is where both need to complement each other and there has to be no conflict. This is where one amendment has been made, because right to privacy is a fundamental right. So if I am sharing any data with respect to any company, and under the RTI Act, that data is being released by the government, is it not a violation of my privacy right? And this is where the Act has clarified that particular thing. So it has amended one of the provision of the RTI Act, that is Section 8(1) subclause J. It is going to make sure that if any personal data is disclosed, is not banned but evaluated in a careful manner. If I have shared any personal data and under RTI, if that data is going to be given as per the RTI Act, then there has to be very careful evaluation of data, and it is going to make sure that again this has to be balanced, that privacy versus public interest. So it codifies the principles the court already follow, that because the PIOs, that is the officers who are going to share any piece of information with respect to RTI Act, they are not in an ambiguous situation. Okay, we are going to respect either the DPDP Act or the RTI Act. This is very much clear on this, and it prevents the clarity or any confusion with respect to the two democratic rights of transparency and at the very same time privacy. Section 8 clause 2 talks about the weightage in terms of maybe deciding that which data is going to be shared and which data is not going to be shared. So again, the idea is, if the public interest outweighs privacy, then which has to be given preference? The public interest has to be given. So again, information must be disclosed in case if there is public interest which is outweighing the privacy harm. Example, disclosure must continue for corruption investigations, misuse of public office, large-scale public welfare issues, and environmental and public health hazards. In such cases, there is no compromising on privacy, and again, the public interest is going to outweigh the privacy over here. Then, overall impact, we have discussed a lot of things with respect to the Act and the new rule. So how it is going to create an impact on which basic sectors? As individuals, it is going to help us with respect to greater control over the data what we are sharing. Number one, strong privacy rights. Again, that it has told us ki as data sharers, if we are sharing any data, what kind of rights I do have. Then easier consent management, then protection from digital harms. Again, a lot of policies have been there, and quick grievance redressal mechanism. The time limit is of what? 90 days. Impact on industry, clear legal framework, that again how you're going to use that data. Again, the whole idea of data fiduciary, data processor, higher compliance standards for the big companies, boost to digital trust. If these companies are complying it with, then only users can trust these platforms. Easier global compatibility with respect to aligning with the global data protection rules, and encouraging responsible innovation around the ideas of artificial intelligence, Internet of Things, and the cloud services. Impact of governance, again we have discussed, it is going to be harmonized with RTI. RTI talks about transparency, DPDP talks about privacy. So again, both are very strong pillars of democracy. So both of them have to be harmonized with each other, which we have discussed. Then strong privacy norms, modern digital first regulatory ecosystem, and it is of course going to be boosting the ambition of India with respect to Digital India mission. Our work does not stop here. Whenever you are reading any topic, you need to understand that again, I am reading this topic to clear the examination. So my understanding has to be clear with respect to how I am going to use this piece of news or this piece of information as far as both prelims and mains examinations are concerned. So as far as prelims examination is concerned, what we have observed since last few years of previous year question paper analysis, that again, with respect to acts, with respect to the rules around the act, the nature of questions around this topic. So again, they can ask questions around the definitions. Who is a data fiduciary? Who is a data processor? The 7 principles around the DPDP Act, what we have discussed, the structure of this board, the penalty slabs, the 250 crore, 50 crore, 200 crore slabs, and aligning that particular act with the RTI Act. Clear? As far as mains examination is concerned, any question which is around the theme of DPDP as a governance reform, any question which is talking about the reforms in the governance process, you can use it as a point. Number one, whenever there is a question around the balancing between transparency and privacy, again, this could be a question for your ethics paper as well as maybe a theme for your essay topic, right? So you can use this as a pointer over here. Then you're going to maybe many times different countries at a global level are coming up with their Data Protection Act. Its comparison of Indian Data Protection Act with respect to the global level. Then impact of this kind of act on paper number 3, that is digital economy. And lastly, the challenges with respect to implementation, capacity, and digital literacy. So overall, let's conclude this. So this act is basically creating something called as a modern, balanced, and citizen-first data protection system. India has now come up with its own law with respect to digital personal data protection. It is going to carefully balance the idea of innovation, privacy, transparency, and different state functions, what we have discussed. It is going to establish strong rights, strict penalties, and digital regulator. It is going to position India as a global leader in responsible digital economic growth. And lastly, it is going to strengthen India's digital future trust. So with this, I hope you got a clarity with respect to the DPDP Act, the DPDP rules. So keep on watching for all such videos. All the very best.